I have the pleasure to welcome Professor Mirjam Eggen. She plays at home. She is an associate professor for private law and financial market law at the University of Bern. Her field of expertise is contract law. She focuses on national and international sales law, but also on contractual relationships between users and providers of digital services, and contractual relationships in the context of all these new technologies and also the Internet of Things. Thank you very much for being here. You have the floor.
Thank you very much, Mr. Müller, for your kind introduction. Good afternoon, ladies and gentlemen. I'm very excited to be here, and I'm looking forward to talking about smart contracts. The term smart contract underwent an inflation with the rise of blockchain technology. But it was introduced and described for the first time already in the 90s. It's even highly likely that most of you already have concluded a smart contract. Allow me to give you an example. Imagine a very hot summer day, and after a long hike, you arrive at the train station without a shop. However, what do you see exactly? You see the vending machine that already Master has mentioned. This is exactly how Nick Szabo explained the concept of a smart contract in the 90s. The vending machine takes your money, and in return it spits out the product you select. This process goes on without any third-party interference. It cannot be influenced, and it's irreversible. Plus, this process is completely automatic. Unless the machine is stopped, then you have to. Now, these are exactly the features that Szabo attributed to the smart contract. Let's go over this one more time. What is a smart contract? After first explaining the term, we'll move on to a discussion about the different relevant legal questions. We'll focus on the implications of smart contracts on contractual obligations, and then on the actual transfer of the goods. In order to define a smart contract, we need to know that the term consists of two dimensions, a technical and a legal one. Now, some legal scholars, define a smart contract solely based on a technical dimension. They describe it as a technology which serves the real exchange of digitally referenced commodities. Other authors base their definition on the application's nature as a legal contract. They describe smart contracts as self-performing or self-executing contracts which are stored on the blockchain. Others again distinguish between a smart contract code, computer program, and the smart legal contract, which means the manner in which codes portray a contract and the way the software executes the contract. Essentially, today there is an agreement that a smart contract primarily represents a software. This software is, like Mr. Collards and Heckman already elaborated, meant to control, regulate, or document an actual exchange of services or other actions that are legally relevant. Now, my following presentation is based on this comprehension of a smart contract. So, smart contract is software, means pre-written logic. So, a smart contract is not a contract in the conventional sense. In fact, it rather serves as a way to ensure the automatic execution of a contract. Wherever these smart contracts are set up, in order for them to be totally automatic and to function without any intermediaries, they require certain characteristics beside a computer code. Ideally, they are stored and replicated on a distributed storage platform, and they run by a network of computers. Now, blockchain fulfills these requirements. Therefore, for the following part of the presentation, I will assume that the smart contract is an application based on a blockchain system. What does this mean? To sum things up, it is important that we distinguish three different levels. First, there's the blockchain level. Second, there's the level of the program code, which determines the functionalities of the smart contract. And then third, there's the level of the individual smart contract, which is carried out between two parties. Well, these are the three levels I mentioned. Now, the legal relationship has to be examined for each of these levels separately. Andreas Fuhrer, for instance, does this very well in his paper, The Embedding of Smart Contracts into Swiss Private Law. So you can read the paper and know everything. In the following presentation, I will focus on the last level. So I'll focus on the specific smart contract. Here's an example of how it could look like. We have Peter and we have, Rachel. And Peter wants to sell his car to Rachel for 20,000 francs. He identifies himself with his public key and uses a smart contract to determine the sales conditions. He signs the contract with his private key. Afterwards, Peter brings his car to a garage which is locked with a smart lock. The car has its own address on the blockchain. As I already mentioned, Rachel wants to buy Peter's car. She signs the smart contract with her private key. In doing so, she initiates that the purchasing price is transmitted from her address to Peter's address. The smart contract between Peter and Rachel is verified on the blockchain. The network checks if Peter is truly the owner of the car and also checks if Rachel has enough money to pay Peter. Once all terms are met, Rachel will automatically receive access to the smart lock where Peter's car is stored. And the blockchain registers Rachel as the new owner of the car, and Peter has 20,000 francs more in his account, while Rachel has 20,000 francs less in her account. So far, so good. However, what does this mean from a legal point of view? In order to answer this question, we have to analyze the following two levels. First, the contractual obligation, and then second, the actual transfer of goods. First, the contractual obligation. At this point, we have to decide what legal role the smart contract plays. This, however, depends on the individual agreement between the parties. There are different ways for the parties to include smart contracts into their agreement. In an extreme case, the parties can use a programming language to write their contract, their agreement, and in this case, the original contract already appears in the form of a code. Alternatively, the parties can set up a conventional contract where they agree on the option of using the smart contract to execute their agreement. Both constellations lead to similar questions. Especially the following two questions have to be discussed. First, how can the smart contract be included into the consensus of the contracting parties? And second, is it possible for parts of the contract to be composed in the form of a code? In the following part of the presentation, I will try to answer these questions, and I'll focus on the constellation where there are two or more parties opposing each other. So there are two or more contracting parties. So I'll not cover smart contracts where there is only one identifiable contracting parties, which also exists. First, we talk about consensus. Contract provisions only become effective if the contracting parties include them into the contract. We all know this. In order for the smart contract to be a part of the contractual obligation, it has to be obviously included in the consensus of the parties. However, we cannot lightly assume that this is the case. There's no clear indication in the parties' agreement that the smart contract is only a tool to help with the fulfillment of the contract. However, it's not to be considered part of the agreement as such. Now, if it is clear that the parties want to qualify the smart contract as a part of the agreement, we have to check additionally if the contractual terms can even be formulated as a software. In principle, it is permitted to include contractual terms in form of a program code. However, both parties have to be able to fully accept the terms before the contract is concluded. First, this means that they receive access to the complete code, and second, that they are able to understand the programming language that is being used. However, we can only conservatively assume that this is the case. If a party is not able to read the code, then it is required to validly waive the opportunity to gain knowledge of the smart contract's contents before the contract is even concluded. Such a waiver should not be easily assumed, especially we cannot assume that by giving consent to use the smart contract for the execution of the agreement, the party also waives the opportunity to take note of the smart contract's terms. In conclusion, it can be said that instead of using a conventional contract for an obligation, you can use the smart contract. However, this will normally not be the case unless there are special conditions. There's no reason to assume that the parties would want to replace an already existing contractual obligation with a smart contract, meaning there's generally no innovation. If the parties agree to execute the contract via smart contract, then in most cases this agreement refers only to the transfer of the goods and does not affect the preceding contractual obligation. So they agree that the contract should be automatically fulfilled with the aid of a computer program and nothing else. While I feel more reluctant regarding the implication of a smart contract on the obligation, I have a different opinion regarding the transfer. If a smart contract ought to be legally relevant, then it must be relevant for the transfer of the goods in question. Before we go into further details, we should discuss the different goods that we can put on a blockchain. Originally, the blockchain has been predominantly used for trading cryptocurrencies such as Bitcoin. Those are normally directly programmed into the blockchain and they do not exist in the real world. Simply put, we are talking about so-called native tokens. However, it is possible to put all sorts of assets on the blockchain. For this purpose, a representative is used. In other words, the value of the asset will be represented by a non-native token. In order to transfer the value, a token will be transferred from the previous owner to the subsequent blockchain participant. From a technical point of view, this concept is absolutely convincing. You move a token which serves as a representative for a specific asset in the real world, like for instance a diamond, a car, a smartphone, and in doing so, the real world commodity is being transferred to the new owner of the token. This transfer of possession is documented on the blockchain, and there is no way manipulation would go unnoticed. Thus, you receive the whole transaction chain of a specific object. Now, what's there to consider from a legal point of view? We already know that tokens can represent everything, practically everything I want them to. That is why a general legal classification seems not only elusive, but also just simply wrong. If I want to know if a transfer of assets using a smart contract is possible, I first have to determine the nature of the asset. Essential, as I mentioned before, essential is the differentiation between native and non-native tokens. Let's talk about native tokens first. Native tokens are, from a legal point of view, tokens that do not entitle its owner outside of the blockchain, thus they constitute pure digital value. The main focus is on cryptocurrencies here, but there are also some utility tokens that are native tokens. Native tokens do not represent relative rights due to the decentralization of the network and the network's users' lack of commitment. There is no counterparty against which the owner of the token could enforce the entitlement that the token entails. Native tokens, in my opinion, also do not represent absolute rights like, for instance, ownership. Now, how do we deal with assets that cannot be legally classified? This is not a new question. There's a common understanding that the law has to take these assets into consideration. There is an agreement that not only objects and rights, but also economic advantages, which is not yet consolidated into rights, or more specifically, all goods which are self-contained and individually existing, can be sales objects, for instance. Native tokens are independent goods that can be validly traded and transferred. The transfer is achieved by giving the receiver factual power. This is exactly what happens when bitcoins, for instance, or other native tokens are transferred via smart contract. Once the code initiates that the native token is moved to the other party's account, only this party will have access to the value. The new owner receives the power and the transfer can completely be executed on the blockchain. What about non-native tokens? This group of tokens gives the owner an entitlement which he can also claim and legally enforce outside the blockchain. The main focus is here on investment tokens, but also utility tokens can be issued as non-native tokens. Non-native tokens can represent relative rights as well as absolute rights. What exactly do I mean when I speak of representation or representative? A non-native token stands for an entitlement which also exists outside the blockchain. If I want to claim or transfer these entitlements, I must therefore fulfill all the requirements that the law demands for these procedures. How does this happen? Some rights can be directly displayed on the blockchain, perhaps because they do not demand any formal requirements or only simple requirements. In these cases, the token directly embodies the right that it represents. Here as well, there is of course no identity between the digital information unit, so the token, and the legal position for which the token stands. This means the token is not a book entry security, instead it only embodies it. It's more or less the container or the wrapper for it. But at least based on the ownership of the token, you can directly assume the affiliation to the right it represents. With other legal positions, such an embodiment is difficult or not even possible at all, perhaps because the state has to assist with the transfer, or because the formal requirements cannot be executed on the blockchain. In this case, there is no actual embodiment of the legal position on the blockchain. The token is only a symbolic representative of the right for which the token wants to dispose. Let's go through a few examples here. If the token represents a movable object, then for an effective transfer, there must be a valid causa and a transfer of possession. In this case, the challenge is certainly the transfer of possession. Approaches can be found in smart property or in so-called Besitzeskonstitution. Let's think back to our car example. Peter puts the car in a garage with a smart lock. The smart contract gives Rachel access to the car as soon as the purchasing price is deducted from her account. So this way, she receives direct ownership of the car. The transfer is executed via smart contract. However, merely transferring the car token into Rachel's account would not be sufficient. As long as she has no real access to the car, the legal transfer has not taken place. Another option for movable objects, such as gold or other precious metals, is to establish book entry securities, but this only under certain conditions. Now, if the token represents an immovable property, one has to consider the special requirements regarding transfer of property ownership. Nowadays, not all of these requirements can be represented on the blockchain unless the land registry, which features such a mechanism, this is not in sight for Switzerland at the moment. The token is based on a claim. An assignment is generally necessary. Formal requirements in Article 165 of our Swiss Code of Obligations are especially hindering and make the transfer of an assignment on the blockchain difficult. Possible is a transfer via contract transfer, so you transfer the whole contract, by innovation, or by booking the claim in question as a book entry security. Organized as book entry securities. I'm sure Lucius doesn't agree with me here, but that's my position. We can see assets can be legally transferred using a smart contract. However, this is, at least today, only possible if the applicable laws requirements for transfer are met. Otherwise, it doesn't work. At last, I would like to very briefly address the subject of default. Smart contracts are made of computer codes. Therefore, their functionalities are predictable, as you already mentioned. Smart contracts are regularly praised for this quality, and it gives them a big advantage over conventional contracts. However, this quality can also have this advantageous effect on the relationship between the parties if the programming of the code or already the expression of the parties' will is flawed. In this constellation, the inability to change the program procedures becomes a burden. One or both parties are not satisfied with the result that the smart contract is producing. What happens? The smart contract does not provide what one or both parties have hoped for. Sometimes it is said that defaults cannot occur in smart contracts because the parties have agreed on the specific code, including all its flaws. In my opinion, that is an oversimplification. We cannot assume that the parties' consensus also covers mistakes done on the level of the code. Therefore, defaults can occur with smart contracts as much as they can occur in other contracts. However, the handling is unequally more complex because of the automatic execution. It is sometimes impossible to stop unwanted procedures. A legal dispute before state court is expensive and time-consuming, and the outcome is often difficult to foresee. In case of an international constellation, there is even more complexity of dispute resolution before a state court is usually difficult, if not even practically impossible. So in order to successfully shield smart contracts from defaults, the following three measures are necessary. First, before a smart contract is put to use it has to be carefully designed and tested. There has to be a comparison between the code and the legal agreement. Second, the smart contract requires a mechanism that solves programming errors and other defaults. In clear cases, an automatic unraveling of the contractual relationship can be programmed directly into the smart contracts code. For more complex instances, an interface to an independent arbitration board should be incorporated. Its role and authority have to be contractually determined. Also, thirdly, the liability for inadequate or even non-performance should be contractually distributed. The fact that at least parts of the contractual duties are performed using a computer program does in general not change the party's responsibilities. However, is the smart contract provided by one party, it should take full responsibility that the program is in working orders. Errors in the code do not cause a disadvantage for the counterparty. Furthermore, the contributing party should not be easily exempt from its liability. In the direct application of the liability regulation in Article 101 of the Swiss Code of Obligations is not possible, it would be beneficial to contractually distribute liability for faults. Okay, so for default, should the contributing party in particular be treated as if it has executed the contract without the support of the smart contract. Now reviewing the past, I hope, 30 minutes, we can take the following message with us. Smart contracts are not just contracts. On the contrary, primarily they are a piece of software, and this software can be used for different purposes. From a legal point of view, it's only in exceptional cases used as an obligation. Generally, it has a different purpose. Namely, it's used as a tool to execute the contract. Ideally, the smart contract can fully ensure the performance of the contract. However, this is only possible if the relevant legal frameworks are carefully debated. In order to prevent misunderstandings between the parties, the smart contract's legal meaning should already be determined before the contract is concluded. Further on, in case of defaults, one should incorporate opportunities for intervention into the contract and maybe even already into the smart contract. We'll definitely hear more about this topic in the following presentation, which I'm greatly looking forward to. Thank you for your time.
Thank you very much for this interesting bridge from the smart contract to the little bit more familiar world of law. Do you have any questions?
My question is about the interaction between the physical and the blockchain contract. You gave an example of a car being sold, and that car being put into a secure garage with a code that would only be released when the transaction was completed. How do you ensure against a vendor putting in a different car, a less valuable car, or nothing at all? Or if they sell a diamond was another example. How do you ensure against a cubic zirconia being put into the container? How does that work?
Thank you very much for this question. First, I think the real problem is really always the bridge between the blockchain and the real world. And I'm sure there are more sophisticated solutions as the one that I mentioned with the smart lock and the garage. You could probably also apply or attach sensors on the car as such. But however, this is actually a huge challenge, and I think that's also the reason why you say, okay, so the main field where blockchain will really work and really where people really can benefit from it is the financial sector. I see also other fields where blockchain could work. For instance, everywhere documentation is important. But again, it's mainly stuff that's merely on the blockchain and not in the real world. So I think you're totally right that this is a challenge to making the bridge between the real world and blockchain. Yeah.
You mentioned that events of default should be foreseen and for part of the smart contract. Now we all know that real life has much more imagination than the human mind. And how do we deal with that? If we are drafting contracts, we're trying to anticipate scenarios. We will never anticipate all of them, but we can deal with them through gap filling. If there's a lacuna in the contract, we can deal with them by using unbestimmte Rechtsbegriff and try to subsume certain events under a provision of the contract. How will the smart contract ever be able to accomplish that? Is that then simply an aspect to that every event of default falls within one of the categories provided for in the smart contract, with no other options being available, or how is the contract to deal with all the potential eventualities?
Thank you. Now, optimistic people will probably reply that it is possible to foresee quite a lot and put it into the code. However, I totally see your problem. I think that's the reason why I say for more complex contracts and more complex constellations, you really need this interface. And I think that's the reason why we're here today, because you could provide such an interface, which then has the means to intervene if there's a problem between parties. I think that's at least a more complex constellation that's really necessary. Yes, I think with really simple contracts, it could be that it's not required.
I would like to thank both conferences for what they told us about Bitcoin and blockchain. But I heard 2 times that blockchain would be essentially of use in the financial sector, and I really don't agree with that affirmation. I will give you one example of what already exists now. Maersk, which you know to be one of the most important carriers in the world, for instance, for using tankers who convey big amounts of petrol from the very east to the very west, has used blockchain precisely to make it possible to diminish the amount of premiums which they have to pay for the route which is used by the captain of the ship, knowing that in the past, when you conclude some insurance contracts for this kind of tankers, one had to calculate the premium of the insurance for all kinds of risks for the ship on 8 different criteria, and using now 27 criteria, where one of those is precisely the route which is taken by the ship and which can be different due to either evolution in the weather, either evolution in the cost and the selling cost of the material which is transported, either the possibility which is announced that there are some pirates in some places or not places. So you have the possibility of concluding a contract with the use of the Internet of Things, and the immediate reaction can falsely influence the financials of the contract you are using with blockchain. And that has nothing to do with the financial application, but only with the interaction between real-world decisions in an ongoing contract. So this is one of the most important things you can do, and you can use also your own. Here in Bern, I presume that you have shared cars, for instance. in Brussels, where I come from, we are not allowed to use the car outside a certain area within Brussels. If I do it, immediately the car is suited by computer, and I get immediately a pop-up saying, oh, you're outside, the conditions are different, you will have to pay more because you're outside of the area. This is the kind of use that blockchain will makes, not only will make, but makes already possible today.
Thank you for your comments. First, I'm not of the opinion that the financial sector is the only or the most important field. I just replicated Mrs. Meisser's statement earlier because it's probably the easiest way to implement it. I think the problem with other sectors, and I also, by the way, I also mentioned that everywhere where you want to timestamp or store information, then it can have its uses, and that's exactly the case that you described with the Maersk case that I'm also aware of. I think the problem is really of bridging the gap between the blockchain and the real world, and we have shared cars, but we also have, I think, shared bikes. Is it in Zurich or Bern? But they were all stolen and they were hacked. See, so that was not with the help of blockchain. But there are. I think everybody is aware of that. There are difficulties in kind of keeping track of real-world assets on a mere digital level. So that's what we're or what probably you should talk, I think, but probably he is less confident that we can make this bridge or build this bridge in the near future in a dependable way. But I'm a lawyer, so I'll give over to you.
So I would say the first use case you described is actually a financial use case because it's an insurance, and insurance is finance. So generally, you have to ask yourself, why do you need a blockchain? And oftentimes, a normal computer also does the job. And blockchain, you only need a blockchain if you have a trust problem. So if you want to eliminate an intermediary, and this is already an abstract problem. So, for example, if you want to have a car that, for example, car sharing, I'm not so sure that you need the blockchain. You can just have a normal server somewhere that keeps track of where the cars are. As long as you trust the company who runs the server, you're okay. It's very hard to have good use cases where you actually need a blockchain outside of finance. Oftentimes, it's not a strict requirement.
Excuse me, can you elaborate a bit on that Maersk contract? For instance, you said there are different factors. Now, one of the factors is pirates. You have a risk factor of pirates in Malaysia, or the Malaysian waters. Now, if somebody decides this risk factor is increased or decreased, somebody has to put it in, and that's the link to the real world. The other factors you mentioned also will have some outside factor. The weather, you may have some automatic information, but all these factors must be quantified at some stage. And the other point with the car, there is the traditional system of certification, which has, in any contract on distance, the solution is certification. But again, that's a link, a standardized form of the link to the real world. So I think even in the Maersk contract, there is this problem of the risk to the link to the real world.
Yes, my answer will be very short. The answer is geolocalization. I happened, just having decided to come over to Bern today, last Monday my car was stolen. I immediately got in contact with the police and with my garage. But there was a chip in the car. and the ship blocked the car, and immediately they knew where the car was, and 3 hours later I had my car back. So, for the ship, it's exactly the same issue. One knows exactly where and when a ship stays. When it moves, one can immediately know exactly where it is the next moment. The contract, which defines, in fact, the highness of the premiums for some kind of risk, is precisely that the premium is precisely calculated in function of the nature of risk taken by the ship due its course from point 1 to point 2. The geolocalization is immediately sent through a system, and automatically, that is defined at the very start, automatically the premium lowers if you take a safe route or not a safe route, depending on the number of parameters you put within the system. And then there, the advantage is that where you decided previously as a captain of a ship to go from point A to point B by a certain route, the same goes with airplanes also. You go from point A to point B with a certain route. In fact, your insurer is going to ask you a premium having in mind that you will have done that way with those risks which are known. You decide, due to the information you have as a captain, within 1 minute to change your route. Could you imagine that you have at that moment to take contact and to have discussions later on with your intermediary on what would then be the just premium you should have paid afterwards? It happens, but it happens after long discussions, saying yes, no, you didn't do that, you could have taken another decision. Now you take just the facts as they were in order to calculate. So you try in insurances to parametrize your premiums. Or
Okay,
what is parametric?
I'm sorry, you mentioned long discussions. Yeah, I think we should perhaps have them during the break.